And we're back with Evidence Made Easy. Evidence is the stuff of lawsuits. Do you have enough? Does the other side have too much? Can you get more? Can you keep out what the other side is trying to get in? All these questions relate to evidence, stuff without which case cannot be won. This tutorial teaches the basics you absolutely must know to win a lawsuit. It doesn't pretend to be a complete treatise of the subject. Some lawyers study evidence and its rules for years on end without learning all there is to know. However, a solid grasp of the fundamentals can give you a decided advantage. And the fact is that many lawyers study evidence rules for years without seeing the simplicity of them. The simplicity set out here in this tutorial, the nuts and bolts simplicity that gives you a common sense understanding of the rules of evidence and how to use them in court to win your lawsuit. The rules of evidence controlling federal courts appear in rule books printed on only 15 pages. State rules are not much more complicated. The subject comprises only a very few simple concepts. It may take years for a seasoned lawyer to master using the rules. However, it is not difficult to quickly grasp the underlying principles taught here. So, without more, let's begin. Everyone with even a tiny smarting of exposure to the world of law and its courts knows that proof is the test by which lawsuits are determined. Proof of the facts based upon admissible evidence. Proving your case is synonymous with winning your case. Proof, however, is based solely on evidence presented and admitted. One cannot prove a case by clever argument alone. No one can prove a case by convincing a jury he's a nice guy who deserves to win. The test of every case is proof that rests on evidence presented to the court in a manner the rules allow to be admitted. Not all evidence is allowed. You may remember the old Perry Mason trials in which Perry objected to testimony with oft-repeated words. Objection, Your Honor. Immaterial, irrelevant, hearsay. The judge responded for Perry, of course, sustained. The objection was sustained. The evidence was excluded as inadmissible. Of course, the jury heard the testimony anyway, but then Perry was sure to pull a surprise at the close of the trial, so it didn't much matter whether testimony was allowed or not. In real life, it matters a great deal. In fact, it is perhaps the most important matter of all. Perry Mason was a fictitious character, always able to pull a surprise at the last minute to win his case. When it's your case on the line, you cannot count on surprises. You must be able to get your evidence in and, as much as possible, keep the other side's evidence out by impeaching it. What follows will explain how to do this by understanding the rules of evidence. Understanding the rules of evidence. The key to understanding the rules of evidence is to see them classified into groups according to application. There are rules pertaining to hearsay, for example, and rules pertaining to relevance, privilege, and witness credibility. Our classifications of evidence rules follows: admissibility, judicial notice, presumptions, relevance, privilege, witnesses, opinion and expert testimony, hearsay, authentication, tangible evidence, and applicability. This tutorial takes each group in turn, explains the nuts and bolts simplicity of each group in terms you can understand and use. We are going to examine evidence rules in a general way. This tutorial is not intended to be a substitute for official rules that control local courts. We will examine rules of evidence only as they apply generally. The rules examined here may not be the same as the rules that control your local court. This tutorial is only a general discussion of rules of evidence as generally applied. Variations may exist in your local jurisdiction. For more information on evidence and specific rules that control local courts, consult your local law library. What follows is intended only to explain in a general way how evidence rules are interpreted and applied. Careful study of this tutorial will help you interpret and apply the rules in your own case, with reference to official rules that control your local court. Following an initial examination of the classification of evidence rules, the tutorial will provide tips on keeping your opponent's evidence out, getting your evidence in, and moving the court to consider all evidence in the best possible light for your case. Admissibility. The most interesting and critical thing about evidence rules is how they apply to admit certain matters to be considered by the court and limit or exclude other matters. This first classification of evidence rules, therefore, deals with admissibility. A witness statement, for example, might tend to prove or disprove some of the issues in controversy, i.e., it might be relevant to the outcome of your case, and yet be inadmissible for one or more reasons. Being relevant alone is not enough. Other factors must be considered before the court can determine if evidence is admissible or not. Each of these will be covered in detail during this tutorial. Some of those factors follow. 1. Relevance. Ability to prove or disprove an issue material to outcome of the case. 2. Credibility. Reliability of the witness or tangible evidence. 3. Privilege. Protection afforded certain kinds of evidence, ergo attorney-client. And 4. Prejudice. Tendency to confuse, mislead, or waste time. If a party offers evidence that is not likely to prove or disprove any issue material to the outcome of the case, not worthy of being relied upon as true, protected by a privilege, or likely to cause prejudice that may outweigh its ability to prove or disprove any issue, it should be excluded as inadmissible, and an appropriate objection should be made as soon as possible, preferably before the court hears the evidence. Unless a matter is admissible, it should never be heard by the court. If it gets in by accident, the too frequent results of unlawful efforts of parties trying to get away with whatever the judge will allow, the matter should not be considered by the court. It should have no bearing on the outcome of the case. Of course, once it's in, it's in. More on handling improperly introduced evidence further on. Only admissible evidence should be considered by the court. Courts are called upon again and again to rule on admissibility of evidence offered by the parties trying to win their case. The admissibility of evidence is ruled on at a trial and all pretrial phases of litigation as well, particularly including the discovery phase. It is unfortunately not at all uncommon for unscrupulous lawyers to try to shift the court's attention away from relevant facts by introducing smoke and mirrors evidence that has no bearing at all on the outcome of the case, but tends to confuse both judge and jury. The savvy litigator is always aware his opponent will try to get in everything he can to muddy the waters and confuse the court. It is extremely important, therefore, to understand admissibility and how the courts rule on admissibility, because keeping the other side's evidence out is just as important as sometimes more important than getting your own evidence in. Federal Rule 1.02 suggests the purpose of the evidence rules to secure fairness, the elimination of unnecessary expenses and delay, and means to ascertain truth and justly determine the outcome of judicial proceedings. The first step, therefore, is to determine admissibility of evidence, whether it should come in or stay out. Ruling on evidence objections. You must object when inadmissible evidence is offered. You cannot allow it to come in then. After you have lost your case, complain to the appellate courts that the trial judge should have excluded it. The rules simply do not work that way. You must object. You must object in a timely manner. You cannot allow a witness to keep on talking and object when it comes your turn to question the witness. You must object right then and there, on the spot, without unnecessary delay. Merely saying objection isn't enough, either unless the basis or grounds for your objection is clearly apparent from the context, and you should never assume that it is. When you object to evidence being admitted, state your reason, cite the rule if you know it, otherwise explain the grounds for your objection clearly. For example, if the lawyer on the other side examining his own witness, he is not permitted to lead his own witness, but is required to elicit the witness testimony by direct questioning only. So if he asks, Isn't it a fact you were walking your dog when the defendant attacked you with an umbrella? That's a leading question. It's improper. You should jump to your feet quickly and say, "Objection, Your Honor, leading." That's enough to preserve your objection on the record for appeal if the judges allowing the evidence to come in is the cause of your losing. You should always object as quickly as you can so the witness hasn't time to answer before you make your objection. If the judge is awake, your objection will be sustained and the other side will be ordered to continue with direct questions only as the rules require. Cross-examination, i.e. using leading questions to interrogate a witness, is allowed, on the other hand, only when you are examining the other side's witnesses or in rare cases where your own witnesses has turned hostile to your case. More on this later. Even though the rules allow objections to be made without stating the grounds, if the grounds are apparent from the context, you are urged to state the grounds for every objection. So there'll be no argument later on as to whether the grounds of your objection was apparent from the context or not. Remember, you cannot appeal a trial court decision based on a judge's exclusion or admission of evidence if you do not timely object and state proper grounds for your objection. That's why understanding the rules of evidence is so critically important. Once a court rules on excluding or admitting evidence and you make your objection and state proper grounds for your objection, you need not renew your objection, unless additional or different evidence is offered, in which case you must object and again state your grounds or be deemed by the courts to have waived your objection. Offer of proof. If you begin to offer evidence and before you can get it before the court, the other side objects and the court sustains the objection, you must move the court to allow you to make clear on the record what the evidence was. This is called an offer of proof. If you don't get your evidence in and don't offer the proof, you'll have nothing to appeal if the courts rule against you, because the record will not show what the evidence would have been. Therefore, when you attempt to get evidence in is prevented by the courts sustaining the other side's objection, be sure to make an offer of proof stating what the evidence would have been and what you intended to prove by it. Then, if an appeal must be taken to a higher court on the basis that you were not allowed to get the evidence in that would have exonerated you, you'll have a record to show what the evidence was or would have been. In jury trials, offers of proof should be made outside the hearing of the jury. In some cases, this may be made at the bench, with the court reporter taking down every word spoken by the parties and the judge, or the jury may be excused. It is common for the jury to be excused and for the party to be allowed to continue questioning a witness outside the hearing of the jury until the judge can determine if the evidence sought is relevant and not otherwise excludable. You can see how much prejudice would result if this offer of proof were permitted to take place within the hearing of the jury. Hearing of the court. It is entirely improper for a lawyer to ask questions he knows will elicit inadmissible testimony. It is against the rules in every jurisdiction. Federal Rule 102C is clear on the subject, stating that proceedings before the court should be conducted to the extent practicable to prevent inadmissible evidence from being suggested to the court by any means, such as by offers of proof, making statements, or asking questions. It is wrong. If it happens in your case, object loudly. Making a record. Remember that objections are only proper where the effect of failure to object would result in prejudice to a party's substantial rights or substantive rights. Objections are made to preserve those rights for appeal as well as to prevent the court from hearing what it should not hear, evidence that might tend to confuse the issue in controversy, mislead the court, or result in undue delay, waste of time, or needless repetition. Objections are made to keep out what should stay out, to let in what should come in, and to establish a record in case an appeal must be taken on the basis that evidence was improperly admitted or excluded by the trial court judge. There is no other reason for objecting. Merely objecting for the sake of objecting or to disrupt the other side's train of thought though too frequently practiced by unscrupulous lawyers, is contrary to both the letter and the spirit of the rules, the spirit of the law, and will result in getting you on the judge's bad side, not good. It is perfectly permissible to object when substantial rights or substantive rights are being threatened with real prejudice, i.e., consequences that may affect the outcome of the case. For example, I have the right to face my accuser. Although there are plenty of witnesses here today, I still don't see the man or woman making a general appearance before this court under the pains and penalties of perjury, willing to testify, independently bonding this case. Okay, and I do not waive my right to face my accuser. Okay, so you want that to be known on and for the record. Object timely and state the grounds for your objection. However, to object for any other reasons is improper and will work against you in the long run. What goes around comes around. Remember, you can always challenge jurisdiction at any fucking time. That means if no plaintiff has come forward with verified pleadings, with an affidavit attached to it stating how he was caused harm, damage, injury, or loss, I'm challenging the jurisdiction at this point. I object to these proceedings continuing on until we can establish that this court's got jurisdiction, which means the real party of interest must come forward stating who, what, when, where, how, and why he was caused harm, injury, damage, or loss, and how he's entitled to it, all right? And this is just elementary, basic fucking shit. But I got a few phone calls today saying, oh man, your videos helped me out so much, so I'm going to continue to do them. Preliminary questions. In determining admissibility of evidence, the court may rule on qualifications of a person to be a witness or to the existence of a privilege. To reach the determination, it may be necessary for the court to consider facts that might not be otherwise relevant, i.e. facts that relate only to the qualifications of witnesses or relationships. Ergo, attorney-client or priest penitent, P-E-N-I-T-E-N-T, priest penitent, that gives rise to a privilege. In such case, the otherwise irrelevant facts are permitted to be heard and generally will be heard by the judge with the jury removed from the courtroom. Remainder of writings or recorded statements. If one party introduces any part of a writing or record statement, ergo a deposition, transcript, audio or videotape recording, or affidavit, the other party may introduce any other part of all of the same that ought, in fairness, to be considered at the same time. One cannot introduce part of such a writing or recorded statement and without the rest. Why? Because it may be taken out of context. So if one part of it's going to be heard, we're going to listen to the whole fucking thing. I don't care if it's a 6-hour fucking saga. We're going to listen to it all. All right? The warning to consider is that if you have a deposition transcript with testimony in your favor mixed with testimony that is not in your favor, take care when you offer the part of you want to come in. Because by offering any part, you open the door to the other side to offer it all. Judicial notice. This is one of the least used yet potentially most powerful tools in any litigation box of lawsuits winning tools. Every jurisdiction we know of allows it. However, very few lawyers use it because perhaps in part it makes the judge work harder, and lawyers often don't want to upset the judges they'll be required to appear before again next week. That being said, this tutorial wasn't written for lawyers who have to appear before the same judge week after week after week, year after year after year. We are only concerned about winning your case, not maintaining a career relationship with a judge. Therefore, if we have to make the judge work just a bit harder to win our case, we'll have no hesitation to move the court to take judicial notice. But what does it mean? Take judicial notice of what? Take judicial notice of the fucking law that we're establishing here, all right, Skipper? For example, all the courts throughout the United States are bound by prior United States Supreme Court cases, period. We're going to make sure that they take judicial notice of that. And we're going to make sure that they take judicial notice of the fact that if we weighed heavily on prior Supreme Court cases to win our case, that is a perfect defense for an appeal. To explain, allow me to digest by telling a story of one of my first encounters with a real live judge. My client had moved out of her apartment, cleaned the floors, the walls, the inside of the oven. Everything was spick and span, tidy, and clean as a pin. The landlord wouldn't return her security deposit, though, so as a young attorney ready to campaign any cause I could find, it seemed reasonable to sue the landlord in a small claims court demanding return of my client's deposit. The landlord had no leg to stand on. We had photographs. We had witnesses who helped clean the apartment. Everything was better than the day that my client moved in. The landlord, not to give up, however, complained, but they cut down my Brazilian pepper tree, Judge. Ah, there at last was the root premise of the defense. My client had indeed cut down the plant, a known nuisance in Florida, where this particular case was filed. Clearing my throat cautiously, I calmly said to the good judge, Your Honor, I move the court to take judicial notice that the Brazilian pepper plant is a nuisance in Florida, and that the defendant landlord has no pecuniary interest in retaining it as an ornamental plant or for any other purposes, so that my client was justified and altogether sensible in her decision to destroy the plant during her tenancy. I'd never moved to court to take judicial notice before, so I didn't know exactly what to expect. To my delight, however, the judge leaned back in his stuffed leather chair and talked for what seemed like a good half hour, explaining his own experience with that pesky nuisance, and, at last, how the landlord would not be heard to complain about its destruction by my client, nor be permitted to retain her security deposit upon the pretext that the plant had any monetary value whatsoever. Judicial notice is the obligation of the court to adjudge certain known facts upon the record of the case, providing that those facts are so generally known within the court's jurisdiction and capable of accurate and ready determinations by resort to source whose accuracy cannot reasonably be questioned, that the fact need not be otherwise proved. A famous case reported to have been won by Abraham Lincoln before he became president of the United States involved the testimony of one who claimed to have witnessed a murder. The witness was so sure of his recollection that old Abe put him to a difficult test, asking him precisely how far away he stood at the time of the crime and how clearly he could identify the accused. The witness testified that although he was several dozen yards away, he could see clearly by the light of the full moon. Abe asked for a brief recess, during which time he consulted the Farmer's Almanac before returning to the court, where he prevailed upon the judge to take notice that upon the night of the murder in question, there was no new moon, i.e., no moonlight whatsoever. The accused was set free. The court's notice was not based on opinion. The court's notice was not based on persuasive arguments by counsel. The court's notice was based on the Farmer's Almanac, a source whose accuracy could not reasonably be questioned on the point. If there was no moon that night, the witness could not have identified the murderer with the precision he claimed. A court may take judicial notice whether or not a party moves it to do so. The court has discretion whether or not to take judicial notice of some matters once it is moved to do so. However, in other matters, it has no discretion and must take notice once a party makes the motion. The distinction is important and will be examined closely. When the court has discretion to take notice, as stated above, a court may at any time on its own motion, sua sponte, take judicial notice of any undisputed fact or law that applies to the case. This happens rarely, however, it does happen, though the court may not formally announce it is taking judicial notice and may merely make a statement such as the court is aware that the highway in question runs generally north and south through this county, or such like statements to move the parties along. In other cases, the court may go on record formally taking judicial notice, ergo judicial notice of the essential elements of a cause of action, or that a certain date fell on a weekend. The court may also be moved by a party to take judicial notice, however, unless the matter sought to be judicially noticed falls into one of the categories where the court has no discretion to deny the motion. The court may refuse to take judicial notice. Examples where the court has discretion include whether conditions on past dates, proper medical procedures to be followed in certain cases, or any such similar matters where reasonable persons might disagree as to particulars. When the court lacks discretion to take notice, shall. If moved to do so, a court does not have discretion to refuse to take judicial notice of facts that admit of no controversy, such as the phase of the moon mentioned above, or the controlling effect of the law within the court's jurisdiction. If the facts sought to be judicially noticed can have no bearing on the outcome of the case, of course, the court is not required to take notice. The fact must be relevant. If moved to do so, and notice is given to the other side, along with sufficient information to enable the adverse party to prepare to meet the request, a court must take judicial notice of such things as acts and resolutions of Congress or the state legislature, the law of any state, contents of the Federal Register, laws of a foreign nation or organizations of nations, official acts of any branch of government, rules of the court, duly enacted ordinances, and general facts that are not subject to dispute because they are generally known, ergo the Brazilian pepper tree nuisance, or because they are capable of accurate and ready determination by resort to source whose accuracy cannot reasonably be questioned. Keep in mind that the court is only required to take judicial notice of the facts that are relevant to the case before it, and the party moving for judicial notice must provide the opposing party with the sufficient information to prepare to meet the request, filing all such matters also with the court. Effect on the jury. All matters judicially noticed should be communicated to the jury with instructions that the jury is to consider same as undisputed facts with regard to each and every matter the jury is called upon to decide. The jury thereupon has no discretion to disagree with a matter that has been judicially noticed as fact. Use and practice. Like everything else in life, judicial notice can be overused and abused to a point of jeopardizing your case. There's no point in unnecessarily putting a judge to the necessity of taking judicial notice of matters only remotely related to your case. On the other hand, if it is relevant to the outcome of your case, to take notice that a corporation was administratively dissolved by the Secretary of State prior to its suing you, move the court to take judicial notice of the fact, providing opposing parties sufficient documentation to allow them to consider the facts in support of your motion, and filing all such documents with the court. Many times, cases can be speeded along and remaining facts dealt with much more expeditiously by moving the court to take judicial notice rather than spending added time and cost calling witnesses to prove what cannot be reasonably disputed. Presumption. This is an interesting area of evidence law that arises where a fact may be presumed once one or more other facts are established on the record. Of course, the weight of a presumption depends on the credibility of the underlying facts on which it is based, and some presumptions are rebuttable while others are not, i.e., they may be refuted and ignored if additional facts tend to undermine their reliability. Some presumptions arise as a matter of law, while others arise merely by inference. A clear distinction between presumptions and inferences will be made in this tutorial. The effect of a presumption often decides the outcome of a lawsuit. However, too many cases are wrongly decided because inference were permitted to be treated as presumptions. It is critically important, therefore, to understand the difference between inferences and legal presumptions. Inference. An inference, like a presumption, is an assumed fact. However, unlike a presumption, an inference arises not from the application of the law, but from common sense reasoning, or, as too often happens, not so common sense guessing or wild conjecturing. For example, suppose you forget to walk the dog and the dog leaves a mess for your wife to discover on the kitchen floor, and she exclaims in tones of hurt and disapproval. How could you? You refuse to walk the dog on purpose. You don't love me anymore. Oh, fuck, we've all been down that path. In fact, you may love your wife very much. You simply have other things on your mind and occasionally forget to walk the dog. It doesn't mean you don't love your wife or that you refuse to walk the dog on purpose just to piss her off, although sometimes we'll let you think that. However, you did not walk the dog, and the mess on the kitchen floor is an unavoidable fact. Inference will be made. Judges and juries are humans too. We all make inferences from facts. We do it unconsciously. Sometimes we even infer new facts from known facts, then make inferences from our newly inferred facts, and the result are often catastrophically far from the truth. In courts, the making of inferences often results in disaster because inferences can be frequently are extremely far from the truth. Presumption. A presumption, on the other hand, is a fact that is established by operation of law, unlike an inference that results from the unrestrained human imagination. Presumptions are the product of courts and legislators that decide certain facts can be determined from other facts as a matter of law. For example, in Florida, we have what's called the carpenter's presumption, a legal presumption that kicks in where a person of some degree of mental infirmity dies, leaving a bulk of his estate to someone who, one, enjoyed a confidential relationship with the decedent and who, two, actively participated in procuring the will. If these two facts are proven, the carpenter presumption kicks in to require the party favored by the will to prove the decedent was not unduly influenced, i.e., that the written will was a genuine expression of the decedent's will, stating that the decedent would have written if he had not been the victim of undue influence. The effect of the presumption is to shift the burden to prove. In Florida, once the party presenting the will to probate demonstrates that the will is valid, properly executed, and witnessed, the burden of shifts to the party challenging the will to show that the two elements of the carpenter's presumption exist. Once the elements are shown to exist, the burden shifts to the person seeking to establish the will to prove there was no undue influence. If the person seeking to establish the will can show there was no undue influence, the burden shifts back and the presumption disappears. Burden shifting may not require a party to prove his case. It may suffice for him to merely present some degree of evidence to meet the presumption without overcoming it. This burden is sometimes called the burden of producing evidence. Consult local rules for details. Whether a particular legal presumption shifts the burden of proof or merely the burden of the producing evidence, the effect is the same. Presumption shifts the burden. In some cases, if particular facts are established on the record, a legal presumption may be conclusive, i.e., unrebuttable. The law will presume that the outcome then and there in the facts supporting the conclusive presumption are shown to exist. There is nothing more for the court to decide. The presumption carries. Most presumptions, however, are rebuttable and all arise from enacted law. The number and nature of various presumptions are too numerous to list here. Consult your local law library to learn more about presumptions. Relevance. Relevance is probably one of the most widely understood concepts of evidence law, and yet the most argued. Lawyers fighting to get evidence in or keep it out are ultimately called upon to argue relevance of the evidence in question. What is relevance? To paraphrase a definition given by the Federal Rules of Evidence, relevant evidence is evidence that tends to prove or disprove a material fact. So, what is a material fact? Suppose you were involved in a traffic accident wherein you rear-ended another car while wearing flip-flops on your bare feet and carrying your girlfriend's picture in your wallet. The flip-flops might have caused your feet to slip off the brake pedal. The picture in your wallet, though, you may have been daydreaming about your girlfriend at the time of the accident, cannot reasonably be considered to have any bearing on the subject matter. The fact you were wearing flip-flops at the time of the material at the time may be material to the outcome of the case. The fact that you had your girlfriend's picture in your wallet probably isn't. If a fact is not material, then evidence likely to prove or disprove such a fact is not relevant and therefore is not admissible. It really isn't and clearly shouldn't be any more difficult than that. Relevant evidence, i.e. evidence likely to prove or disprove a material fact, is generally admissible. Irrelevant evidence isn't. Evidence is only properly admissible when its introduction is reasonably likely to prove or disprove a material fact. If that fact may be proved by offered evidence is not material, if that fact that may be proved by offered evidence is not material, i.e., if it will not tend to decide the case one way or the other, then the evidence is irrelevant and should not come in. The sad fact, however, is that many unscrupulous lawyers, in their mad haste to make as much money as possible in the shortest length of time, regardless of what may or may not be true or just, introduce irrelevant evidence in an effort to prejudice the court. Such irrelevant evidence may seem to address itself to some material facts. However, on closer examination, it is found to be nothing more than smokescreens to hide the truth. An example from a real case follows. A very successful multi-million-dollar businessman operated almost exclusively upon its creative use of certain trade secrets, without which it could not have made a dime. The CEO of the company met with the owner of a competitor company and agreed the two of them would create yet a third company that the competitor would eventually purchase for a substantial sum by paying the CEO millions, of course. The CEO in turn, stole the trade secrets, left his once successful employer, and started a new business with a great deal of financial support from the competitors, who looked forward one day to owning the trade secrets and the new business, while the CEO enjoyed the millions he was promised. After the victim business owner filed the lawsuit to recover damages from the CEO and the competitor, the defendant claimed the victim's business owners had prior dealings with a man who had gone to prison 6 years prior, and alleged that because the victim business owners had once dealt with the man who is now a convict, that they should not be permitted to sue the CEO or the fund providing competitor, insisting on introducing evidence of the prior dealing with this bad man as probative of their defense. Their defense revolved around the ridiculous theory that anyone who ever makes a mistake by dealing with someone who later goes to prison should not be permitted to sue for damages they suffer at the hands of a thief. In other words, it's all right to steal from someone who once knew someone who was a thief. They had no other defense. The court finally ruled that such evidence was irrelevant and would not be admitted, since it would not tend to prove or disprove a material fact, i.e., it would not tend to prove or disprove whether the CEO and his conspirators stole the victim's company's trade secrets. It's always a good idea to be on your guard for such tactics, prepared to argue against the introduction of irrelevant evidence, i.e., evidence that cannot reasonably be expected to prove or disprove any material fact. When we come back, we're going to be talking about prejudice may exclude relevant evidence.